Great. Let's get started. Thank you, everyone, for joining us tonight. My name is Michelle Isherwood. I'm a member of an alumni member and a member of Humphrey Chapter, formerly of the San Francisco Alumni Chapter. And now I'm out here in New Hampshire, so I'm a member of the New Hampshire Alumni Chapter. Tonight we have a really interesting guest, Phil Cave. He is an alumni member of the Reading Chapter, and he's been practicing military law for over 42 years. He's going to share his insights with us. If you have questions, please put them in the Q&A box and we'll monitor them and we'll get to the questions at the end. So again, thank you for joining us. Thank you, Phil, for coming on tonight, and take it away.
All right. Well, good evening, and thank you for joining us. We're going to talk a little bit about military justice. If you are reading the newspapers, listening to your favorite news channel, you, without realizing it, are getting a lot of talk about military justice issues, be it people or events and those kind of things. For example, today, the sailor accused of setting fire to the Bonhomme Richard had his preliminary hearing. So that's all over the news about his potential court-martial. Court-martials are rough justice. That's a meme that's continued for many years. So for our purposes, American military justice begins with the Continental Congress adopting the British Articles of War for the Continental Army. They existed without much change until the 1920s, shortly after World War I, when some argue the Houston Mutiny, the court-martial of quite a few black soldiers and executions, created generated the reform movement that continues today. But for our purposes, military justice starts in 1950 with the Uniform Code of Military Justice. It's a standalone criminal law system, and we'll talk about that some more. Like anything, well, one distinction, it's an Article I court, not an Article III court. But it quacks, so it's a duck, and it barks, so it's a dog in many ways. So Congress makes the rules, the president issues supplementary rules, and then the secretaries of the services and military commanders can issue rules and regulations that in many instances can be what we call punitive. In other words, you could be prosecuted at court-martial for violating those rules. Status. Since 1993, Solorio, the Supreme Court, has said that anybody wearing the uniform can be court-martialed. It doesn't matter where the offense happened, what they did, who they did it to, victims, those kind of things. It's based purely on status. And as a regular component retiree, it matters to me and many of my friends and colleagues, because we are still subject to court-martial prosecution for things we did on active duty, but more importantly, things we might do today. The one thing you may not be aware of is that civilians who went to Iraq or Afghanistan over the last years, they also can be subject to court-martial. The Supreme Court said back in '55 that once a service member has completed their contract, as opposed to going into retirement, they no longer are subject to jurisdiction, even for crimes committed while on active duty. And since Reed in 1956, we know that a spouse of a service member located overseas cannot be prosecuted at court-martial for murdering her spouse. There are statutes in place now, the Military Extraterritorial Jurisdiction Act, for example, which has changed that, but it goes to federal court. And one of the issues we'll talk about towards the end here is federal court litigation challenging some of the retiree jurisdiction. We'll get there. You can be court-martialed for military offenses, as you can imagine, but also in the articles, most of the common law offenses you will find in the UCMJ as articles for which you can be prosecuted. You get to the Article 133 and 134, which we call the general offenses. And it's basically if the military thinks you did something wrong and it will make the military look good, or it's not good for good order and discipline, they can invent a crime. It's a rather interesting litigation track when that happens. A couple of differences that you won't find in federal court. One of the punishments you can be given at court-martial is, quote, no punishment. The idea being that the conviction is enough. And of course, reduction in rank you don't see, and the punitive discharges. Be careful here. Bad conduct and dishonorable are for enlisted people. An officer gets a dismissal. And you have to distinguish between that and administrative discharges, which are called other than honorables. Many people who are not familiar with the subject automatically think an OTH is a dishonorable discharge. It ain't, okay? You have to be a general court-martial to get a DD, or as we sometimes say, a duck dinner, or a big chicken dinner if you get a BCD. A little bit of courtroom humor always helps things along. I mentioned the death sentence penalty. Private Bennett, last one to be executed in 1961. Right now we've got 4 on death row. And you'll notice gray, his conviction was in 1988. And that's still being litigated in federal habeas, even now, even though President Bush signed his death warrant. So current issues. Just last week, the Congress finally passed the National Defense Authorization Act for 2022, which has got some significant changes in it, which I'll talk about here in a moment. Some of you may have heard about, we call it MJIPA, the Military Justice Improvement and Increasing Prevention Act. Senator Gillibrand, Representative Speer, and a number of others have been pushing this legislation appropriately for 10 years, I think, at this point. And it's all focused or related to military sexual assault problems. In addition, recent studies have suggested that racial disparities in military justice have continued. So Congress is finally getting around to working on things that people have recommended for more than 100 years. The military commander gets to decide who gets prosecuted at court-martial. He or she also picks the jury. The analogy I use is the manager of the New York baseball team gets to pick the umpire or gets to pick the players from the other team. Okay, that's the best analogy I can give you. Up until, well, these changes take effect 2 years from now. So at that point, we will change from to a judge alone sentencing. Before that, you had a choice. The judge or the jury could do the sentencing. The other thing is that for the first time, we're going to have some sentencing parameters, is what they call them, guides or guidelines, those kind of things. The problems left on the table, there's still no jury, random jury selection. Again, the commander still gets to pick the jury. There are some limitations on access to the Supreme Court in terms of an appeal. And post-Ramos, if you're familiar with Ramos v. Louisiana, earlier, this year or last year, the military is now the only criminal jurisdiction in the United States where you can be convicted and sentenced to death. Well, sorry, let me rephrase that. Convicted and sentenced up to LWOP, life without parole, by a jury of 8, where only 6 have to vote in favor of guilt or innocence. So those will be matters still to be litigated. Retirees is a particular issue because of the ongoing litigation. A lot of retirees. I think you may be familiar with Lieutenant General Flynn. He's a retiree. All of the things that he was accused of doing wrong while serving in the White House or in his private business, he could be court-martialed for. It's not going to happen because I think judiciously, that's being left to DOJ, Department of Justice, and the U.S. attorneys to take care of. But he is subject to court-martial for everything. The one point here is, I think I mentioned this, I could rob a bank today, and I'm subject to court-martial jurisdiction for that. And there's no double jeopardy because it's a federal jurisdiction. So if the Commonwealth of Virginia, where I live, wanted to prosecute me and I got acquitted, the military could court-martial and those kind of things. So let me skip over Major General Grazia Plain. The point there is they were going to court-martial him. There was a problem with the statute of limitations, so the Commonwealth of Virginia ended up prosecuting him for crimes that had been committed over many years. Perhaps this one might interest you a little bit more. You may remember the picture of Lieutenant Colonel Larry Brock, United States Air Force retired, making his speeches and such on the floor of the Senate. There were calls for him to be court-martialed. The problem is that under the statute, under current law, he is not subject to court-martial jurisdiction. He's what we call a reserve component retiree. Okay, so that's the law. Is the best I can tell you. Okay, current litigation. There is a Marine or sailor who serves 20 years can transfer into what we call the Fleet Reserve. At that point, they get a retirement check. Their obligation is to be available for the next 10 years for involuntary recall to active duty to serve. And that happens from time to time. These three Marines were living and working overseas, retired, committed serious misconduct, were convicted at court-martial, and they've been litigating the constitutionality of subjecting retirees to court-martial. The U.S. District Court for D.C. Year before last decided that yes, the statute is unconstitutional. So the Circuit Court of Appeals for D.C. heard oral argument, and we're expecting a decision perhaps at the end of the year or early in the new year. Almost like certainly that will then, the loser is going to petition the Supreme Court. We're not sure what the Supreme Court will do because, as you can see here, Larrabee's original petition on direct appeal was denied by the Supremes. And if you understand how that works, that's not a decision on the merits. Mm-hmm. All it is saying we don't want to hear the case. So this is, for us at least, a current live issue on jurisdiction over 2 million people at court-martial. And since 1955, we found 31 cases of a retiree being convicted at court-martial. That doesn't mean to say there weren't others who were prosecuted and acquitted or were convicted, but their sentence didn't warrant a mandatory appeal from that. So this number is low, and it could be a little bit bigger, but certainly not much more. So that's the down and dirty on military justice. I've hit a lot of different things there, and I'm going to, at this point, if I can get back to the full screen, Michelle, and we can do questions and such. Sure.
I think, let's see. If anyone has questions, please go ahead and put them in the Q&A chat box and that we can ask them. I have a question, actually.
Yep.
So if you're a retiree and they do court-martial you, do they bring you back to active service and
Sure.
then court? And then would that person serve out their time in a military facility, or would they serve time in a civilian?
Good question. So Major General Flynn was not recalled to active duty. It's not the practice to recall officers. They just give them the paperwork and say, show up on this date and time. They have a choice, appear in uniform, or as Grazio Flynn did, in civilian clothes. He's leaving a pretrial hearing in his case. If they are convicted, depending on the sentence, they will serve the sentence at the U.S. Disciplinary Barracks, Fort Leavenworth, Kansas. Or there are several other facilities where if the sentence is 10 years or less, there are some Navy brigs and Army facilities around the country where they would serve the sentence. Does that help?
That does help. We have a question. What are some different routes to practicing military law?
Excellent. Go Navy. No, seriously. In 1978, actually, I joined the Navy JAG, or Judge Advocate General's Corps student program in my second year of law school. It turns out I did the right thing because it helped with the multiplier on my retirement check. But I served 20 years. I have friends and colleagues who've been judge advocates in all of the services, including the Coast Guard. I don't know if it'll help. I've talked to Emily about maybe getting the JAG recruiters to come to one of the annual events, but you can go online and look. If you look for Navy, Army, Air Force, JAG recruiter on the Google, you should get their information. One of the things I do, I'm involved with several organizations, and we have law students as interns, and most of them have gone JAG. So you can become a military lawyer. Typically the commitment is for 6 years, but you can do what I did and make it a career, at the end of which you get a retirement check, but most importantly, single payer medical insurance. So if you want to be recruited, and look, I served 3 overseas assignments. I went to Gulf War. I served 2.5 years on an aircraft carrier as the legal advisor. It was a lot of fun and at times miserable. Most of us enjoy it. So I just gave a recruiting spiel there, I think, Michelle, for JAG. But again, I for obvious reasons, I think the Navy is the place to go.
You must have inspired people, because our next question is, any advice for someone applying for the Navy JAG Corps?
For Navy? Yeah. Do well in school. I'm reflecting back partly. All the services are looking at the top % of the class, in terms of academics. Okay. I would suggest that if you want to get a leg up, then things like community service or involvement in things beyond going to class, whether it be moot court or there are many law schools around the country who have veterans clinics, for example. So participate in that. They don't do, mostly it's to do with veterans law, disability issues, other things that are administrative in nature, but doing those kinds of things, be more than just a student who's getting good grades, I think is the way I would recommend it. Now, I've over the years, I've certainly talked to a lot of people who would like to join, and sometimes it's something about you that makes you stand out, or a person of interest, and I don't mean that in the FBI sense, but something that makes you stand out.
So we also have a couple questions from some of our pre-law and undergraduate students.
Yeah.
And they're wondering if there's any way coming from undergraduate perspective, is there a JAG route before going to law school, or
No.
is there a route that you could go and be in the military and attend law school?
No, I don't believe there is. There are any number of people who've become JAGs who were enlisted people and served their enlistment and then went to law school, and then applied to be a JAG because for obvious reasons they got a leg up there. There is a program for people who are already what we call line officers, in other words, not JAGs. It's called the Law Education Program. So in your third or fourth year, you can apply to be selected, and they take 5 or 6 people each year and pay for them to go to law school. But again, you already have to be a line officer to get into that. And I can tell you the cutting score to get into that program is pretty significant. So unfortunately, no. Now, each of the services specialize internally. Okay, there are a lot of us who spent our careers doing military justice, criminal law. We have specialists in international law, international humanitarian law, law of war, medicine and hospital law, tax law, contract law. So I think what I'm saying there is one of the things you might think about is what elective classes you take that might make you attractive in that sense. National security, if you, GW has a national security law program, Georgetown, other schools. So if you take a class or two from them, and that's on your resume, that might be something to help, because it shows you're interested in the underlying topic of serving your country. Does that help?
Yeah, I think that helps. And then here's another one. What are the 11 areas the commander will lose command power to charge under the NDAA?
Yeah, I don't have that in front of me, but they are all of the sexual assault offenses, murder, all forms of murder, including manslaughter, sexual harassment, retaliation, and I think I may be, child pornography. So those are the topic areas. I just forget which articles. It'll take me a moment to pull up the list, but there are some victim crimes that they've left off. For example, they've left off maiming and child endangerment where there's a victim. But that's the focus, and this is politics and sausage making. The recommendations that many of us made and got in and helped, we didn't do it, we helped do it, got into the initial legislation, took everything away from the commander except purely military offenses. But no, I won't say that, it's too political, but there was a meeting of 4 people, the 2 chairs of the House and Senate committee, and they negotiated and compromised, which has led to some change. I and many others would say unsatisfactory, but sadly they've, rather than look at a complete reform of the system that was really needed, they have focused it on just the sexual assault areas, which many of us think will be bad for victims of sexual assault, as it turns out. But I'm getting too far into politics here.
This one maybe, but I guess somebody's asking for your thoughts on why do commanders who have little to no legal experience hold so much power? Do you think this will change? I often hear it's done for good order and discipline. This participant says they served 20 years in the Army.
Yeah, well, that's always been the point. Commanders have always had that power. They've resisted removing that power all along. The NDAA has changed that for some for these 11 offenses. The person with the power is going to be they're going to create a special trial counsel prosecutor who is a JAG. It'll be a somewhat stovepipe organization where it will be the JAGs and the lawyers making the decision on whether there's probable cause, whether to have a preliminary hearing, whether charges should be prosecuted. In that process, clearly there will be offenses identified that are purely military. And so there's going to be a process where they can slice off the pure military offenses and give them back to the commander, if you will. But that's been the commander-centric model has existed forever. As many of us know, the British, Israelis, Germans, Australians, Canadians, and French, and some other countries have either wholly or partly removed commanders from the process. And that's been a process that they've gone through over 20 years now, going back to litigation in the European Court of Human Rights and in the various countries' Supreme Courts, where they've separated out what we think of as common law crimes, murder, mayhem, robbery, assault, and I think people are starting to appreciate that there's a system of military discipline and a system of military justice and they sort of they exist together, and people are in fact, I think the decision by Congress in the NDAA is I would argue the biggest thing to happen in American military justice since 1775 by removing commanders from part of that process. The problem is they still left the ability to pick the jury, which means they can influence the decision. One of the problems is commanders who like the accused, so they would put people on the jury who they thought would vote in favor of the accused, and vice versa. I mean, in other words, they hate the accused, and if that person's been in the army for 20 years, they know what a scumbag is. Okay, so somebody who gets identified as a scumbag, the commander might be inclined to. Now, that's I should say that's an overly cynical view. And that is one side of the continuum on the idea of reform. And then the colonel is right, or maybe lieutenant colonel, that the good order and discipline has always been foundational for a military justice system. But and those against reform have argued that all these reforms will destroy good order and discipline. Yet there is nothing to suggest those countries have lost good order and discipline where they made changes. There was a study done of the First World War some years ago now, of it focused more on deserters and cowards who were executed, but it looked at the British justice in the trenches, if you will. And interestingly enough, the consensus opinion was it's not the existence of the death penalty or very severe punishment. It's all about leadership. In terms of how you could get people to go over the top, right? I mean, to climb up on step and then go over the top in the face of machine gun fire. So a long way around of saying, yes, that's the argument that this is the only way to enforce good order and discipline. But there are arguments to suggest that it's not going to be the end of good order and discipline. And yes, we need cultural change, right? If we're going to attack military sexual assault, it starts with the culture. And that culture starts with the family, the schools, et cetera, et cetera. But anyway, that's a perhaps too philosophical view.
We have another question. It says, in my experience, panel members are pulled by the legal office from a pool of all eligible officers at a station or base and
Right.
sent to the convening authority, who doesn't specifically ask for particular members. Why do you think this process is biased?
Oh, the argument against that process is that person is correct. I think it's fair to say that all the services, either once a year or twice a year, put together a standing panel, and they reach out. It is the SJA, the Staff Judge Advocate, the legal office, who does that, and they will present a list of people that they think are qualified under Article 25 as the most appropriate members. Okay. And I did this myself over 20 years, helped the CO or the commander put together a list, a jury list, if you will. The problems happen when they start to stack juries. And we have a number of cases over the years. There was a case not too long ago where the jury of 10 had 5 women, 4 of whom were sexual assault advocates, when the number of women in that geographical area was a lot less than 50%. So that's one example of how it can be stacked. The other issue that's percolating is there's a case fairly recently. The commander in that jurisdiction, 10 consecutive court martials, everybody on the jury were white. And I forget how many of the accused in those cases were persons of color. Now, the cynic will say, well, that's stacking because they only pick the white guys. Okay. The other problem with that is military panels tend to pick people of seniority. Okay. So if you think about it this way, in terms of the number of officers of color, or women for that matter, in the military, we're still at that point where most of them are at the junior ranks. So it's that process, that factor, if you will, that tends to find more white guys being put on the panel. And so it looks like people are picking just white guys. Okay, if I'm making sense there. That is one of the reasons why people who advocate reform have suggested that random selection, in other words, you pick a pool of 100 and you randomly select, would be a way to compensate for those what are systemic difficulties there. And we know it can work because some years ago, this is exactly what they did with a case in Iraq. The deniers, if you will, argue that these things can't be done downrange. In other words, in Iraq or Afghanistan or whatever. But it worked. Now, I agree it was only one case, and certainly there haven't been a sufficient number of cases to see if it was a one-off situation or if it really could be a consistent process. But that essentially is what the discussion about. And I forget if your questioner was Air Force, but yeah, I mean, I think you can look at many appointing orders, because that's where they put out the list of who will be on the jury. And there's nothing obvious about them that would suggest there's been any sort of jury stacking or discrimination or whatever. So that's a sort of the lay of the land, if you will, about what's going on.
Another question here. It says some states have independent military forces. Example, Texas, the Texas Guard, California, the Cal Guard. What is the procedure for dealing with issues that arise with these units? Are they subject to the UCMJ, or is it strictly a state issue?
Sure. So every state has a National Guard. Virginia, we have a militia as well, which is total state, not federalized ever. So in many others, there's a model National Guard UCMJ that some states follow, but every state has their own variation of the UCMJ, which their National Guard operate under within the state. Now, when the National Guard is federalized, they are put on Title 10 orders. They then become subject to the same rules as the active duty. Okay, so for example, the DC Guard, right, in January. I don't remember, I'd have to think whether they were federalized for that or whether they did it under their DC role. So let me pick a different, a natural disaster where the Guard units are federalized. In other words, they're brought under federal regulation, which means instead of reporting to their state governor, they report finally and up through the President of the United States as Commander-in-Chief. They would then be subject to the same UCMJ as the regular active duty force. But when they're in their state, they're subject to their own state UCMJ or statute. West Virginia, for example, their cases get tried in the regular, I forget whether they call it district court or whatever their trial level court is, criminal trial level court. Other states have a separate standalone. Delaware. Many years ago, I represented a service member. Bo Biden was the prosecutor in that case in Delaware. They have their own standalone system. So every state is somewhat different on that. And it just depends on how the state has things set up. On the militias, and I know we've been hearing talk about this, I forget whether it's Florida or Texas, they want to stand up, maybe it's Florida. They want to stand up some strange unit, but those would be totally outside anything of what I think of as the UCMJ. Like I say, the Virginia militia, organized and uniformed, very similar to the Virginia National Guard, but totally state regulated.
Here's one. It says I am doing our Air Force ROTC at the moment, and I'm preparing to go to field training this summer. My plan is to go to law school after commissioning. Do you have any tips for cadets or the process of going JAG while being an undergrad regarding internships or AFSC job selection?
That's probably somewhat out of my lane. Most of the ROTC cadets I've represented are getting disenrolled, not trying to stay enrolled. I suppose that part of it must relate to you've got a service up. Sorry about that, the timer. I'm not sure how it worked with the service obligation that you have when you complete ROTC, but you may be one of those people who have to do your initial contract and then somewhere during that apply for the LEPA program and hope you get selected, or do any number of my colleagues served their first commission tour, left active duty, and paid for their own law school, and then did come back to be JAGs. So they lost out on the taxpayer paying for their law school education. But other than that, I really am not sure.
What is your thought on making the jump from being a JAG to then working in DC in a policy role?
A little bit out of my lane also, other than I have friends and colleagues who are assigned that as part of their military duty. We deal a lot with several uniformed people who are staffers for Senator Gillibrand, for example, and several other senators. Again, part of the organizations that I work with or am part of. It's like anything. If you have some background in the subject and you go on to be a policymaker, arguably you make better policy or you give better input. There certainly have been plenty of JAGs who moved over to being staffers. In fact, one of them just retired as the Chief Judge of the Court of Appeals for the Armed Forces, Stuckey. He was counsel for the Senate Armed Services Committee for many years.
Let's see, how often do you see civilian military defense attorneys represent military members during your career? Or how often did you see?
Significant, and more. When I was on active duty, 20 years of active duty, I saw half a dozen. Okay, but over the last 10 to 15 years, you will see a lot, and that's because, well, there are a number of factors. One is advertising and the accessibility of information about civilian lawyers. I mean, there's maybe 30 of us in the country who do this 24/7. There's another outside ring who do it as part of their practice. But once you've done something for a long time, then people are coming to us for our experience. They will tell us, well, civilians can do things my military lawyer can't. That's true and not true. If the implication is you can do unethical things and get away with it, my military lawyer can't, it ain't happening. However, as a civilian attorney representing somebody at court martial, who has 100% of my allegiance? The client. So one of the concerns, and this is something that these are questions or points made to us all the time when we're talking to a client or potential client about hiring. I don't have to worry about my career. I don't have to worry about upsetting the prosecutor because next week or next month or next year, he'll be my boss or vice versa. I don't have to worry about the judge. There are a lot of things that are direct or indirect pressures that most military lawyers deal with very well. I was one. And I will tell you, I'm not one of those civilian counsel who goes around dissing the uniform lawyers. It's just not appropriate because there are many, they're just young and inexperienced. So that's the issue. And yes, because of the most of our dockets, at least the people I have, a large proportion are sexual assault cases. And it really takes some experience beyond having done a dozen or two guilty plea cases or contested trials. When you've done, I mean, any experienced lawyer will tell you, the more you operate in the courtroom, the better you should be at it, and that's where the experience. And it, you know, the point is that I guess this is an advertisement for those of you who do go in the JAG Corps, do your 20 and get out. There's a good opportunity to make a living.
How much investigation occurs before a charge is brought under the UCMJ?
It varies. On the more serious cases, the Military Criminal Investigative Organization, which is the MCIO, which we call now, which could be NCIS, no crime investigated sufficiently, Army CID, clowns in drag, Air Force OSI, or the Coast Guard Investigative Service. Most of them are pretty basic investigations. In fact, you know, they interview a few witnesses, they get a confession, and they hand it off to the prosecutor, at which case that's when the prosecutor learns not to rely on the investigation and do their own investigation. They can take months. I have clients even now, and I have over the years, who we've had as clients under investigation for a year or more before the decision's even made to start the court-martial process and do the charge sheet and the preliminary hearing and those kind of things. And the quality, this is one of the things that has been addressed already in various studies and investigations, is the quality of the military, of the MCIO investigations varies dramatically. And they found a lot of problems, for example, with the Army CID, partly as a result of the Vanessa Guillen case at Fort Hood. So they've done a major change on how they're organizing Army CID to try to improve the quality of the investigations. In the Army, you can become a CID agent now at the E5 rank, which means you've been in the Army 3 or 4 years. NCIS are all civilian, and most of them, not all, have been anywhere from 5 to 10 or so years in civilian police department. Many of them been detectives who've come to work because the federal check is better and benefits is better. So a long way around of answering, it can take a long time, and the quality is not always that good.
Here's a question. Why do you think the military justice system is so irreparably broken that discipline should be taken out of the hands of the commanders?
And who are you quoting for that?
There's a question here in our,
yeah. Where's the question? Where's the quote?
Oh, it's in the Q. It's not in the Q&A. It's in the chat.
Yeah, I'm trying to remember where that quote comes from.
I'm not sure.
Well, that's typical hyperbole. That's the problem with the discussion that's ongoing.
Yeah.
There is a lot of hyperbole on both sides. And some of us try to modulate it, but yeah, that is some people's view.
And then I have a couple more questions. One is, I think you've addressed some of this, but are there any other ways to practice military law from a civilian perspective?
There are a number of organizations and law firms, obviously, who that's their practice. Veterans organizations. It depends on what kind of law you want to practice. Okay, if you want to do courtroom law, then in the military setting, then the only way to, I think the only way to do that is go uniform and then transition and stay in it. If you're a person who is good at admin law, and I don't mean this to be pejorative or negative, I hate admin law. Okay, my brain doesn't work very well on admin law, but there are other people who it's perfect, who that's the kind of thing they're really good at, and that's good. So veterans organizations, a number of organizations out there who do pro bono work, primarily for veterans, those would be some of the ways I would think you could get into the business. Court of Federal Claims is you have to have some understanding of the military and military system if you're doing military cases in the Court of Claims, mostly pay claims. You know, somebody gets discharged and they're not getting paid, or there's all kinds of ways you can get into the Court of Federal Claims as a active duty or a retired or a former service member to make a claim for pay. That might be something. So I'm not sure that helps.
And I have one last question. It says, as an undergrad, would it be appropriate to speak to JAGs now about wanting to explore that route, or just approach recruiters?
I think you should do both. When you talk to the recruiter, okay, the more you know about the military and possibly about military law when you have that first and subsequent interview with a recruiter, or the person, the lawyer they send out to do the field interview of you, the more you can talk as if you know a little bit, doesn't that boost your credentials a little bit? In other words, you've already taken the interest in looking into the topic and subject of military law. You know, you don't have to be able to write a book or a law review article about it. But if you've taken the trouble to do a little bit of research about military law and read all kinds of different things, just follow the news. Follow us on CAFLOG. I suspect some of the audience know us at CAFLOG. And get an understanding and appreciation that might help you impress the recruiter, or each of the services will send out a lawyer from a place, from an office near where you are, to do a face-to-face interview, although maybe with COVID, they're doing Zoom interviews. But maybe that's something that would boost your creds a little bit, that you've already taken the interest. You know, it's not one of 10 job interviews you're having, right? That maybe is something, and you can learn that from talking to JAGs, or if you live near a military base and find out when there's a court martial going on, go watch. Or if you're I don't know if there are too many active duty people going to law school nighttime, but you know, those kind of things.
Well, and I have one more suggestion. As a pre-law or law or even alumni that's interested, I would reach out to other Phi Alpha Delta members. We have several that are practicing JAGs, that are retired JAGs who practice in various areas of military law. I would encourage you to reach out to them. Our directory you can search the directory and it'll give you names. You can also reach out to the executive office. Feel free to email me, I'll find you somebody. Or you know, your district justice in your area, or the alumni chapter, and really use your Phi Alpha Delta network to meet people and have questions answered. And I think it's valuable, and it's a great part of your membership. So that's it for questions. I want to thank you, Phil, for coming on and sharing your expertise and insights. It was great. We really appreciate members like you that come on and volunteer to do our speaker series. So thank you so much.
All right.
Thank you, everybody, for coming on. Stay tuned. January, we have a great panel on work-life, kind of work-life balance, new year, new you. Hope you have a great holiday season, and we look forward to seeing everyone after the new year. Thank you. Good night.
Cheers.
Bye.